seated. Ms. Hayes, we're on the world break. Well, we sort of figured that's what happened.
I'm very sorry. I actually was taking my time getting it because I let the girl get it. I thought it was...
It's okay. We sort of figured that you're pretty reliable, and so that was the natural guess on our part. All right, let's consider Delta's fire sprinklers versus ONEBEACON 043349. You want rebuttal plan?
Yes, please. 5 minutes.
Yeah.
May it please the court, today we're here on the merits portion of this case. There's 3 things that I would like to discuss. One is we didn't file a common law bond claim because the notice of non-payment was late. Number 2 is there's a lot of reasons in good faith why one could be expected to file a common law bond claim in the alternative based on this bond. And number 3 is that the Bridgeport Inc., Bridgeport Strasburg joint venture distinction is not a distinction. So starting first with the 713.23 bond claim, we didn't file a common law bond claim because the notice was late. In order to accept the fact that the notice was late, one would have to measure the 90-day window from within which there is to serve a notice of non-payment from the date of the second to the last payment application of the project. The surety ONEBEACON has litigated this case for 6 years when its own representative admits under oath that work required for our contract and final payment was done on January 23, 2001, 48 days before service of
the 90 days. Is that the punch list and inspection?
It's the final inspection, Your Honor? Yes.
Well, aren't you? How do you deal with cases like Viking Builders?
Well, in the Viking Builders case, there was weep holes and a thermostat put in the wrong place on the wall. The weep holes are in the windows, and that's what lets the water run back out.
But you had one guy working on this project and was called back to kind of look around and see what needed to be done. Very minor things, and in fact, if you look at the payment schedule and the progress reports, it appears that everything, the major work had been done, and you're doing what I would call cosmetic or fix little things so that it looks good or that it's working properly. Well, we don't understand.
Actually, as a matter of Florida statutes and the building code, the fire sprinkler contractor has to be present for the final inspection, or
Right.
Human beings can never occupy a building. So it's got nothing to do, in all due respect, Your Honor, with cosmetics. It was 3 guys that were there on the project during the week of January 26th, and that's when the CO for the clubhouse was issued. It wasn't a repair. It wasn't a warranty call. It was work required according to the surety's own testimony pursuant to our contract. Now, before 1990, 713.23 said you have to serve your notice within 90 days of the date your payment was due. But the legislature changed that so that it would match 255.05, which says the 90 days of the last labor, services, or materials being furnished to the project. But even if we went on when payment was due, since they're using a payment application that shows unearned money of $23,000, unearned and unbilled. If you go off the final payment application of 12/25, then it's 77 days to the notice of non-payment. If you go off our last day of work, it's 48 days. If you go off the owner's affidavit, it's 20 days. If you go off the contractor's affidavit, it's negative 16 days from the date of our notice of non-payment. No reasonable surety anywhere, I will assert to you, would ever make this argument. There's even their own principle. If I could bore you with just a few citations to the record, was asked, when would you be able to tell that Delta was 100% complete? Answer, Delta's last pay application to me. Now that's in the record at volume 8, page 1103. The last payment application, 77 days from the notice of non-payment. We asked Mr. Martin, who's the licensee, the principal in Bridgeport, and the only signor on the account of Bridgeport Strasburg joint venture. We asked him, do you know if the fire sprinkler sub is required to be out there for the final inspection? Answer, most of the time you have a project manager do a walkthrough with the fire inspector, with the fire inspector to verify and be able to tag. Question, who's project manager? The one for Delta and the superintendent for Bridgeport Strasburg. That's at page 1140 in the record. Affidavit of Rich.
So what were they out there for?
They were out there, they actually have to operate the system, turn it on, tag all of the valves so that it's actually turned on, so that the water's flowing.
With the inspector?
Yes, exactly.
So then the CO can be ordered.
Right. Then if there were a fire, the system would work and it also notifies the fire department with a silent alarm. So all of those things are not hooked up until the last day for obvious reasons. The construction's still going on the project, the water's not turned on to that system, that is all done at the conclusion. Even in the affidavit of Mr. Martin used to support the summary judgment, he says in January 2001, Delta Fire Sprinklers did have to return to perform work necessary to obtain a final inspection and certificate of occupancy. That's in our initial brief appendix at tab 4, page 5, and volume 3, page 450 of the record. The owner states, I believe that I said it was completed about February 1st, 2001. That's well within, that's about a week after our final furnishing. In the owner's affidavit, it says that Lakeview Club entered into a contract with Bridgeport, Inc., and that on or about 2/20/2001, Bridgeport, Inc. submitted its final payment application certifying work was completed, including the Delta Fire Sprinklers work. So going from 2/20/01, we have 20 days to the service of the notice of non-payment. Affidavit of Alan Lougheed is an expert witness that is a contractor and architect licensed in the state of Florida with a great deal of experience. Mr. Lougheed says in the record at page 921 that the inspection is critical to the project, that the contractor has to tag all the valves in an open position and ensure the water flow alarms are operational. If the fire sprinkler sub is not on the job, the CO will not be issued.
How would you distinguish the Leader Mortgage versus Rickards case where the subcontractor had said they were 100% paid, but then tried to make the argument that although they were entitled to be paid 100% at an earlier date, they hadn't done 100% of the work?
Well, the thing about that case is it's a final contractor's affidavit case. They're arguing the final contractor's affidavit wasn't due, and so they didn't have to file it before they proceeded with the lawsuit because the payment wasn't due. It's distinguishable. It's not measured. It's not a measurement like this where the statute says the last furnishing of labor, services, and materials.
Well, but didn't your client in November say we've done 100% of the work?
Yes, it's industry standard for the client to bill for everything except the retainage at substantial completion, and that's exactly what our affidavits say. That's the way the construction business works.
So we should ignore what he said then?
Well, he says in there unearned and unbilled is $23,000, so I think you can take it into consideration that's on there. But according to...
Was that retainage?
That's the retainage, yes, sir. And that's withheld until the work of the contract is completed.
Till the final payment.
Right. Even if you bill 100% on the first day, it doesn't change what the statute says. It says the last furnishing of labor, services, and materials. And in this instance, it was clearly the last week in January.
Was there anything done from, what was it, pay application 14, I think it was, where it said 100% completed? Was there anything done by your client between pay application 14 and the final inspection?
Well, there was a number of COs issued during that period. I don't think that the contractor's records as far as his actual timesheets or people that went out on the job reflected very little. Between that time, there was some things in December, and then there's a December 25th payment application for the last $23,000, and then there's the January 23rd work.
December application was for retainage work.
Yes, and that's within 77 days. So even if we ran it off of that, when they finally billed for the last amount. But I could bill for the last amount today, and I could still have a door that I haven't put in, even though your house is completely built. I could have an interior door and go out there next week. That still would be my final furnishing, regardless of whether I billed you for everything. It just doesn't, one does not equal the other, and that's why the statute was changed, because it used to be tied to payment, but it was too much of an obscure date and a difficult date to fix. The affidavit of Chuck Montgomery, 36 years of experience in installing and designing fire sprinkler systems. He says that the CO permitting use of the structure by human beings will not be issued unless Delta Fire Sprinklers operates the system for the fire marshal at the time of the final inspection. In the surety's representative's deposition, this is in the record of case 3349 at volume 6, page 607, we asked, I'd just like to ask, in general, if the final fire inspection on January 23rd, 2003 had never happened, never passed, never got closed out, would Delta have been entitled to payment? The surety's rep, Martin Cohen of Boston, Massachusetts, answers, the obvious answer is no. So if we could never get paid until we did that work, how can that work not be a final furnishing? They know it's a final furnishing. They know, or they should know, it's a final furnishing.
Doesn't that depend on what your contract says?
Yes, sir.
Doesn't your contract say that the retainage is going to be withheld until the final payment?
Our contract says we'll be paid when they are paid by the owner. It's got a pay when paid provision.
Well, that doesn't necessarily mean there's any work done between the final draw, or between draw 14 and the receipt of the retainage. It just means that you have a contractual obligation which says we're going to wait for that period.
Yes, but what Mr. Cohen is saying is that until that final inspection and the CO was issued on January 23rd, 01, we weren't going to get paid on the contract.
So you consider a final inspection substantial work?
I consider it a furnishing of labor, services, and materials. I do, in fact, Judge, consider it substantial, because you can't occupy the building, and everybody in an apartment complex probably wants to have a working fire sprinkler system. But it's clearly, in Mignall, which is a case out of the fourth, one of the most recent cases looking at this, a fax was a final furnishing, because the fax was sent in an attempt to resolve an issue over the trusses on the building that was being constructed. All of the cases that are cited by ONEBEACON fit into one of two categories. They're either before 1990, when the notice was tied to payment, or they are repair work cases, where, someone goes out and does a warranty call on a compressor for an air conditioner and then tries to use that as a date to back into a 90-day notice. Deposition of Robert Martin, everything in the record supports our position. I think the law clearly supports it. If nothing else, in a de novo review, I would respectfully request the court look at the appendix to the initial brief, which contains every affidavit that was filed, including Mr. Martin's affidavit. And the court will see, if nothing else, there's no way there's not a question of fact here about when it was. And I would say, as a matter of law, it was resolved in our favor. And on that issue alone, the case should be reversed with direction to enter judgment for Delta Fire Sprinklers. Moving quickly to the topic of the common law bond. As I stated, first and foremost, we didn't do the bond claim. This is different than professional plastering. They didn't serve any notices. We served our notices. We didn't.
How do you distinguish this case from the Second District Court of Appeal case involving the same bonding company, as far as statutory versus common law bond? And if you get more, it's one thing. If you get statutory, it's less. So how do you distinguish that case? Forget professional plastering, but how do you distinguish that case?
Well, in that opinion, I'm not familiar intimately with the facts of that case. I know that we actually drafted the complaint, my office did, but I cannot.
Well, let's just talk about the reported opinion then, where the court described why they were calling it a statutory bond, even though all of the requirements were not met.
Well, in that case, they looked at whether the improper recording of the bond turned it into a common law bond, which we also have in this instance. In this instance, we have two other things that are not discussed in that opinion. In fact, one that is said to not exist in that opinion. One is this bond expands the class of claimants. That is a classic reason that a statutory bond becomes a common law obligation. It expands the class of claimants by saying anybody who's a subcontractor doesn't have to serve a 90-day notice. 71323 says you do have to. The bond says, no, you don't. You're still going to fit into the class of claimants that we're going to permit to have a claim on this bond. The other thing is they can say all day long that ONEBEACON is licensed to conduct business. That doesn't change the fact that the statute requires a licensed surety and that the name on the bond is General Accident Insurance Company, which is not licensed. And in the record are certified copies from the Department of Financial Services at Volume 7, page 977 through 1006, certifications that General Accident Insurance Company is not a surety authorized to do business. So the statute says the payment bond required to exempt an owner under this part shall be furnished by the contractor in at least the amount of the original contract price. It's not. Before commencing construction, it's not. It shall be executed as surety by a surety insurer authorized to do business in the state. It's not. And it expands the class of claimants. So clearly this bond is distinguishable. And what does that mean? That means that we didn't even have to serve a 90-day notice. And if the court finds that it's a common law bond, we have to get real quick to the issue of Bridgeport Strasburg versus BSJV, which I will submit to you is exactly what the name implies. Mr. Martin testified under oath that they're one and the same, that it was just a name that they used. It was a name they deliberately used to avoid paying people, to put people down a tier so they wouldn't do their notices properly. But there's only one individual who could sign checks, who was involved in both businesses, who was the licensee. BSJV was an unlicensed contractor that under 489-128 could not have even legally entered into a contract with Delta Fire Sprinklers. Thank you.
Right. Grant, you ready?
Good morning again, Your Honors. Bill Grant on behalf of ONEBEACON Insurance Company. I find it surprising that Ms. Hayes would make claims regarding the record about Mr. Martin testifying that this BSJV was just a name, or that it was somehow created to avoid claims. There is no record testimony, anything like that. In fact, the appellant attached to their brief as an appendix the affidavit of Mr. Martin, which was misquoted earlier. In addition to the misquoted portion, Mr. Martin testified that Bridgeport Strasburg joint venture and Bridgeport Inc. had separate bank accounts. Bridgeport and Bridgeport Strasburg joint venture had separate federal employer ID numbers. Bridgeport filed tax returns. Bridgeport Strasburg joint venture filed tax returns under Bridgeport Strasburg joint venture every year. That they were separate and distinct entities, properly set up, and to say otherwise is just absolutely contrary to the facts of this case. She conveniently skipped over some words from Mr. Martin's affidavit. She read the affidavit to say, in January 2001, Delta did have to return to the project to perform work necessary to obtain a final permit. The part that she skipped over was when he said, in January 2001, Delta did have to return to the project to perform punch list and warranty work necessary to obtain final inspection. That is the affidavit of Mr. Martin. And for her to say, to skip over the punch list warranty work is to ignore the Florida cases that say that type of work is not the type of work that extends the time for filing your notice of non-payment.
Did Delta have to return to power up the system in the presence of the fire marshal?
Delta was at the final inspection, just like the contractor has to be at the final inspection. Every trade has to have their work inspected. Every permit has to have an inspection. That's normal on every project. And
that punch list or warranty work?
Sir?
Is that punch list or warranty?
No, sir. There's no question but that Delta came out one day, one affidavit from Delta's representatives say they came out on January the 23rd. Another affidavit says January the 25th. The corporate representative of Delta also testified on this subject, and he was talking about this testimony is from Noble Dixon, the designated corporate representative for Delta Fire Sprinklers, who testified that a gentleman by the name of Jose Ramos, he did the final that day for a particular building. Was an answer. He was talking about Jose, and I asked, what does that entail? And Mr. Dixon testified, walking the building down with the fire inspector to make sure it meets compliance and is ready to be turned over. That is just a few minutes. There were 3 buildings that had to be inspected. The remainder of the buildings had already been inspected long before that. And that probably did occur on January the 23rd or January the 25th.
So what test do we apply to that?
Excuse me, sir?
What test is to be applied to that sort of?
The substantial trivial test that is expressly identified as the test in the Excel case from this court in 1996, Your Honor, where you look at the nature of the work being performed and determine if it is of such a trivial nature as to not extend the time within which you must file a notice of non-payment. The Viking Builders case, this court expressly said that just because the owner insists that that work is necessary under the contract does not extend the time for serving your notices to come back out and do minor trivial work. It is significant, Your Honor, that on November 14th of 2000, Delta submitted a payment application that said in no uncertain terms they were 100% complete with this project and certified that payment application as being 100% complete and all work having been performed. But not only that, their own project cost accounting time records for all employees working on the project are detailed, long, multi-page lists of all the employees that worked on the project and when they worked and their payment shows that at that time, during that week, November the 14th, 1 Delta employee was at the job. Their application did not seek retainage for another $23,000, but it absolutely did just a few days later, in early December. They sought the remainder of their payment, and that application is dated I apologize, Your Honor. I do not have that. I have it on a blow-up. Delta attached it. It's dated early December. It does say period through December the 25th, but no work was performed.
Are the applications for payment sworn?
Yes, Your Honor, by Robert Gibson was the November affidavit, and notarized as well.
Usually hasn't been sworn.
So the significance, Your Honor, is, as Judge Nelson properly pointed out in the hearing on the motion for summary judgment, Delta finished their work on or before November the 14th, 2000. And they actually, yes, it was 2000. They came back out for the final inspection to walk around the last 3 buildings with the inspector. That event occurred more than 10 weeks after the final furnishing, but it could have very well occurred 6 months or 8 months later, where someone walks out onto the job, walks around with the inspector, and leaves. This particular instance was Jose Ramos, who came out, according to Noble Dixon, representative of Delta Fire Spring. And also in the deposition of Mr. Dixon, he talks about the punch list work that they came back out to perform in late January. That the punch list that is information that is referred to in Mr. Martin's affidavit that they came out to do. Apparently there was a valve that was either broken or was not installed. In his deposition testimony as to the nature of the punch list and warranty work that they came out to do. That punch list, that warranty work, did not extend the time for Delta Fire Sprinklers to file their final notice. Now, it is again appalling to ONEBEACON Insurance Company for there to be any type of claim about its ability to issue surety bonds in the state of Florida. I checked online and have a copy of the certificate that was filed.
Is it in the record?
The certificate is, Your Honor. The dates of the corporate entity are also on record.
Now whether it's on the record, but is it in the record?
In the record before us?
Yes. As far as the timing of the change of names of the company, it's cited also in the brief, the answer brief. You can, and I ask that you take judicial notice of this because you can take judicial notice of facts that are readily ascertainable. ONEBEACON has been licensed.
Wait a minute. Unless it was before the trial court.
It was, Your Honor. Absolutely it was.
Unless that document was before the trial court.
I
don't think we're going to be taking judicial notice.
Well, the document was before the trial court, Your Honor.
All right.
But I looked it up and confirmed it online.
There's a method where you can ask judicial notice to be taken, and doing it at oral argument is not it. ONEBEACON Insurance Company has been licensed in the state of Florida since January 1, 1957.
Is there anything in the record contradicting the affidavit that you all submitted on this issue?
Delta filed a certificate from the Department of Insurance Treasurer / the Commissioner of the Department of Insurance and Treasurer that said that as of the date of that March of 2002, that General Accident Insurance Company was not licensed or authorized to transact business. This bond was issued in 1999. There's nothing about the license status in 1999. This clearly, and the record reflects, that ONEBEACON changed its name to CGU, and then later, I believe at that time, was in fact ONEBEACON Insurance Company. And General Accident Insurance Company of America was the original company that originally became licensed January 1, 1957 in the state of Florida to sell insurance, including surety bonds, and has been a continually licensed company for, I know it's been 48 years because I'm 46, and it was 2 years before I was born, more than 2 years before I was born. So they've been licensed for a lifetime, at least my lifetime. It's just baffling that they would even try to suggest that ONEBEACON was not licensed at the time that it issued that bond. If you compare that certificate...
Let me get you off on a different subject. It has occurred to me that this is a summary judgment.
Yes, sir.
It's occurred to me that the test, and I think you're correct in describing the test as a trivial substantial test. Doesn't that, would you say that a trial judge having to determine what's trivial and what's substantial introduces a factual issue into this matrix?
No, Your Honor. ONEBEACON did not dispute the fact that Delta came out and walked around the project to perform an inspection.
So the fact of the inspection is conceded.
The fact of the inspection is conceded. The fact of the inspection is undeniable. I mean, they're not in the record, and I don't believe they were in front of the trial court either, Your Honor. That you can look at inspection certificates and things of that nature. It is unrebutted, and as Judge Vander pointed out, the case of Rickards Electric says, and it is indistinguishable, you cannot have your cake and eat it too. You cannot say we are finished with our work for billing purposes, but not finished with our work for purposes of compliance with the lien law. That is exactly what that case says. That is the law. You cannot say we are completely finished. They billed for retainage. And I could get the date. Well, you asked me not to play them, but we could blow up our record document.
It's in the record. If it's in the record, you can show it. If you created it for this argument, you can't.
This is the...
That's a big help.
application for payment, Your Honor. This is the cover sheet of that application for payment. It's signed and notarized. They billed for the retainage. There's nothing left to bill. It's dated December 8th, 2000. And their own payroll record shows that there was no one out on the job between November the 14th and December the 8th. It was just when they billed for their work. It was December the 8th, 2000. That's still more than 90 days from the time they served even if you count December the 8th as the date of final furnishing. But you can't. And I'm not asking this court to look at the application for payment to determine final furnishing. These are evidence, Your Honor, because these documents have attached to them the continuation sheets. And every one of the continuation sheets, November the 14th, 2000, say they were 100% complete with every item of work. The same information is contained in the 14th and 15th payment application. In fact, I've pulled out two pages. One is the December the 8th second page, the same second page, and each one of them there identical, and there's a continuation sheet that say 100% of the work has been performed. Nothing changed. You look at their time records, there weren't any employees out there doing any work. There was nothing going on between the time they submitted that December the 8th application asking to be paid in full for their retainage. But again, you don't look at the application for payment because that's not the law. These applications are admissions on the record by Delta Fire Sprinklers that in fact they were 100% complete. That occurred on or before November the 14th, 2000. And as a result, they failed to timely serve the notice of non-payment. And having failed to serve their notice of non-payment timely, Judge Nelson correctly determined that undisputed issue of material fact that the walking around the job with the inspector to turn on a valve so that water would trigger the alarm 3 times isn't enough to extend the time within which to submit your notice of non-payment. So there is no affidavit from the owner that says when Delta final furnished. There is no affidavit from the contractor that says when Delta final furnished. Suggestions that those documents exist and say something about when Delta was finally out on the job are not in the record, and I challenge the appellant to show this court where they are if they believe that it is. Nothing says when Delta final furnished except their own documents, their own payrolls, their own applications for payment. That the Records Electric case says your time begins to run. You cannot have your cake and eat it too. The time begins to run when you say you're finished and you've billed for 100% of your work. You cannot have it both ways. You cannot say we're done for billing purposes, but we're not done for the lien law purposes. We do not have yet to comply with the lien law, even though we're completely finished with our work, until something else occurs. That's not the law in this state. The law in this state is the work that you perform must be substantial work related to the contract. And that did not occur after November the 14th, 2000.
Okay, thank you,
That's
counsel.
all we ask, that you affirm the trial court.
All right, Ms. Hayes, you have 4 minutes and 47 seconds.
The Rickards case is not applying a statute that says, quote, "A lienor is required as a condition precedent to recovery under the bond to serve a written notice of non-payment to the contractor and the surety not later than 90 days after the final furnishing of labor, services, or materials by the lienor."
You saying the Ricketts case is wrong then, and we should not follow it, or agree with it?
It's actually not wrong, but it's not on this statute. It's got nothing to do with the bond, 71323 bond claim. It's, did you serve your contractor's affidavit? The affidavit itself relates to payment, and that's a payment, was that affidavit timely? This is a case where when was the last time that you were out there that governed, that...
Do you have a case that says that an inspection is work or substantial work, or providing of labor?
Well, the substantial trivia test has been rejected by the Florida Supreme Court.
My question was, do you have a case?
Where
I
was
have one that says that a fact, Your Honor, but not an inspection. I have one that says a fact is sufficient. But it was rejected by the Florida Supreme Court, and the standard is, and this is in my brief at page 14, the Florida Supreme Court's test for determining whether the nature of the work performed is contemplated by the construction lien law is whether the work was performed in good faith within a reasonable time in pursuance of the terms of the subcontract and necessary for a finished job.
What's the site?
That is, I cite to McNall, which is 842 Southern 2nd, 927, but it cites to the Florida Supreme Court authorities on that. It gives you a...
842 Southern 2nd, 927?
Yes, sir. Even in the professional plastering case, I know I keep coming back to that, but in that opinion, the quote is made that the service has to be not later than 90 days after it finally furnishes labor, services, or materials. Other cases involving ONEBEACON, the Tampa case.
Well, all of those cases depend on what you define as, and that's my question. Do you have a case that defines an inspection as following under that clause that you want us to hang our hat on?
Well, Your Honor, I don't have a case that addresses an inspection, but the case law is, was it in good faith, which clearly there's no evidence it wasn't. Was it within a reasonable time? It was whenever they call for the final inspection. The contractor is in charge with finishing the project and getting that done.
As far as providing your services, do you disagree that you said that the work was last completed in November of 20?
Yes, I do. It's industry standard to bill for everything except the retainers. And the pay application that he's referring to that says December 8th says for the period, so that's forward billing through December 25th. I mean, you can't just ignore that. That's the pay period that's in there. That's within 77 days. On the Bridgeport, Strasburg issue, the affidavit of counsel said that there's nowhere in the record where Bridgeport has said that that was the date in question. Well, in the affidavit that's behind tab 4 of our initial brief appendix, Mr. Martin from Bridgeport states Bridgeport's final furnishing of labor, services, or materials on the project was more than a month prior to April 30th, 2001, and the certificate of occupancy for the last building was issued in January 2001. So he is acknowledging his deposition. We had to be there for the CO to issue. He says in an affidavit that that was in January 2001. He says that they were out there as of the end of March 2001, still working. In the record at volume 8, page 1062 to 1329 is his deposition, and included with that is where he is writing at Exhibit D, he's writing to the surety, and he's saying enclosed are the spreadsheets for our subcontractors, Bridgeport Inc. And sure enough, the subcontractors include Delta Fire Sprinklers. So that Bridgeport Strasburg joint venture distinction, there's nothing in the record except information that indicates that it was formed as a sham to try to avoid paying the lienors. The joint venture agreement, I want to finish on this point, it's actually in the record of the South Trust case with the operable amended complaint, states, Strasburg hereby acknowledges that Bridgeport is the sole licensed general contractor for the project under Chapter 489 of the Florida statutes and has certain responsibilities thereunder. Strasburg agrees that to the extent that any part of this agreement is in conflict with Bridgeport's rights and obligations under Chapter 489, that such rights and obligations shall control over any conflicting provision of this joint venture agreement. They had to be licensed as Bridgeport in order to enter into our contract.
Thank you.
I really want to deeply apologize for being late. I feel terrible about it. Sorry.
Don't worry about it. We've all done the same thing.
Thank you.
Thank you. Well, Judge Thompson, for the rest of us.